The next matter to come before the court this morning is State of Ohio versus Jacqueline Ware. Both sides have 15 minutes to argue. Appellant may reserve up to 5 minutes for rebuttal. We've read the briefs. We're ready to proceed when you are.
Thank you, Your Honor. I reserve 5 minutes for rebuttal. May it please the court, my name is Attorney Neil Agarwal. I represent the defendant, Jacqueline Ware, in this matter. Your Honor, the facts of this case is that there was a party, and a lot of people were drinking, as they often do at a party, and two women got into a fight among other people, and my client, for lack of a better word, won the fight because he supposedly took a knife and sliced or cut the face of the victim. She was charged with felonious assault. Now, during the trial, which the defendant maintained her innocence, the judge said, "I think there is enough evidence here for the jury to acquit her of felonious assault, but find her guilty of the M1 simple assault." And we're in agreement with the trial court up to this point. However, where we think the trial court made reversible error is he told the jury during the jury instructions that you can only consider the M1 assault if you first find the defendant not guilty of the felonious assault. His specific jury instruction was, and this is on page 5 of my brief, if, and this is the quoting where the judge said, "If you find that the state has failed to prove beyond a reasonable doubt that the defendant committed the crime of felonious assault, you will then consider whether the state has shown beyond a reasonable doubt that the defendant committed the crime of assault." As far as filling out the jury forms, the trial court then instructed the jury saying, "If, and I repeat this, only if you have found the state has failed to prove either count 1 or 2, or both beyond a reasonable doubt, you would then consider whether or not they have proved assault." So there is no doubt that the trial court jury was instructed, you cannot get to the simple assault unless you first acquit her and find her not guilty of the felonious assault. Now, that goes in contravention of Ohio law, which that is considered an acquittal first jury instruction. The Ohio Supreme Court has specifically said you cannot instruct a jury, that you can't consider the lesser included misdemeanor only based upon an acquittal. For example, if this jury was deadlocked on the felonious assault, 11-1, 6-6, it doesn't matter. They couldn't reach a felonious assault. Under the jury instruction given, they can never get to the misdemeanor because they had to first acquit her of the misdemeanor assault. Now, the state, in its brief, is saying, no, Mr. Agarwal has completely wrong. The trial court gave the right jury instructions. I have with me a portion of the transcript, and this is also cited in my brief, but on page 626 of the jury instructions, or of the closing arguments, this is what the prosecutor told the jury. Now, quote, "Now in the instructions, you have another option. The state is not asking you to consider that. The defense is, it's assault. You only consider that if you find the defendant did not commit the felonious assault." Defendant's attorney says, "Objection." Trial court says, "Overruled." The prosecutor goes on to say, "So consider the 2 counts of felonious assault. If she's guilty," she told you she is, okay, "then that is what you should find." So here, the defense attorney objected when the prosecutor says, you don't consider the assault unless you find her not guilty. Defense objects, and the trial court says overruled. So the trial court believed that was the correct instruction to the jury. The defense attorney believed it, and the prosecutor believed it. So all three at trial were told, and the jury certainly believed, you can only get to the assault if you find not guilty of the felonious assault, and that is fundamental error, wrong. And there was objection by the trial counsel throughout. The state says in its brief, well, this is only plain error. Defense attorney did not object. But if you read the transcript, Your Honor, I cited multiple times in my brief, where defense counsel says, I object to this sequencing of events. Now, the second and third assignment of errors, Your Honor, are more technical, but the state has conceded the assignment of error on number 2 on giving the notifications of post-release control. When a defendant is sentenced, you have to give certain colloquy requirements when considering post-release control. The trial court did not do that. They were put in the journal entry. The Ohio Supreme Court has said they are mandatory, so that has to be reversed and remanded as far as post-release control. The third assignment of error, Your Honor, is also a technical argument. Under Ohio statute, when a person is sent to prison, you must tell them that they are not to use drugs in prison and that they are subject to random drug testing. This court has held that assignment of error in and of itself is not reversible error. However, if we are reversing back for resentencing on any other assignment of error, then we will instruct the trial court that they are to comply with this statute. So if the court is going to reverse on assignment of error number 2 and 3, then we would ask the court this court to order the trial court to follow that colloquy. If there's no further questions, I'll reserve the remainder of my time for rebuttal.
You'll have 5 minutes for rebuttal.
Thank you.
Thank you.
May it please the court, Helen DiMartino on behalf of the state of Ohio, the appellee in this matter. We are asking that this court confirm Ms. Ware's conviction for felonious assault as well as the sentence that was imposed by the trial court. With regard to the issue of the jury instruction, the state would note that on page 7 of the appellant's brief, he does refer to the standard of review as plain error. In fact, counsel did not object to the jury instruction that was given, which is why at this point, appellant's counsel is noting that there was an objection made during closing argument, which has absolutely nothing to do with the jury instruction that was given. That's not part of the standard of review on how we examine whether there was an appropriate, applicable, correct statement of the law given to the jury. An argument based on one objection to a characterization of the state's argument, which is to be given wide deference, has absolutely nothing to do with how this court should analyze this jury instruction.
Might it be, however, some evidence of prejudice because of everyone in the room's understanding what the jury might have believed to be the case?
I don't see how it can go to prejudice or how it can show what everyone believes the case to be. The state was giving an argument based on the facts and based on saying that Ms. Ware basically has confessed to this. You know, the issue was not so much a cut with a knife. She had very sharp rings on the victims, and the victim's face in this case was severely lacerated. So I don't believe that his argument goes to the actual circumstances of this case. With regard to the jury instruction that was given, when you look at it, it complies with Ohio Jury Instruction 42509, which is the applicable jury instruction. The court stated on page 675, if you find that the state proved beyond a reasonable doubt all the essential elements of either or both counts of felonious assault, your verdict must be guilty. Then the jury went on and complied with the second paragraph of OJI 42509 and said, if you find that the state has failed to prove beyond a reasonable doubt the defendant committed the crime of felonious assault, you will then consider whether the state has shown beyond a reasonable doubt the defendant committed the crime of assault. There's nothing.
Excuse me, isn't there another small portion there that says, or if you cannot all agree, then move on?
That is what the jury instruction said. Those are the pages of the jury instruction.
You're telling me those are the ones that were given?
That were given.
I'm asking you if,
if they
the
should
guide
say
on jury instruction says, or if you cannot
Right, it
all
does.
agree.
Yes, it does. And he's arguing that the court's instruction that was given somehow advised the jury that they have to all get together and first say not guilty, and he's implying and adding things that were just not in the record. The instructions that were given are a correct, accurate statement of the law. They comply with the Ohio Jury Instruction paragraphs 1 and 2. He has not established that there was any error, let alone plain error in the instruction that was given, which is his burden, and therefore the state would argue that his first assignment of error lacks merit and should be overruled. With regard to the technical arguments that he raises with regard to post-release control, the state would note that Judge Kimbler, who is a visiting judge sitting on assignment, did put in the journal entry that if the defendant was found guilty of violating the terms of post-release control, up to 1/2 of the prison term could be imposed pursuant to 2919B2E, and that it could run consecutive to any sentence imposed for the new offense pursuant to 2929-141A. However, that was not stated during the sentencing hearing. Again, the appellant is asking for this to be reviewed under a plain error standard of review, and the state would argue that this is not something that requires certainly the sentence to be vacated. If the court finds that these technical issues need to be advised orally at sentencing, then and only then should the matter be remanded solely for the trial court to orally tell Ms. Ware that if she violates the terms of her post-release control, those two particular aspects of PRC could be imposed. And if the court does send it back for those two things, then I would agree that certainly the final assignment of error, that this instruction could also be given to Ms. Ware. If there are no questions, I'd rest on the brief.
Are you troubled by the language, if and only if you found the state failed to prove beyond a reasonable doubt felonious assault by proof beyond a reasonable doubt, you would then consider whether or not they proved assault?
No, and that is not, I don't find that troubling at all. The issue that appellant is raising is that this was a instruction that the court told the jurors that they had to find unanimously that they could not go on to the lesser included offense, and that's not.
Well, you would agree that a jury is not required to unanimously determine that somebody's not guilty of a crime before it considers a lesser included offense, would you not?
I would agree.
Okay.
Thank you, Anderson.
Mr. Agarwal, you have 5 minutes.
Thank you, Your Honor. May it please the court. Your Honor, the state in its brief on page 5 does set out the OGI, Ohio Jury Instruction 425.09. The last sentence of its paragraph under the jury instruction, the proposed one, if all of you are unable to agree on a verdict of either guilty or not guilty of the greater offense, then you will continue your deliberations to decide whether the state has proven beyond a reasonable doubt the essential elements of the lesser included offense. That is in the jury instruction. That is what was not given in the jury instructions to this trial jury. So that is the crucial sentence. Now, the state is saying the defendants did not object, but on page 5 of my brief, I specifically stated where the defense objected on page 627, and then at the very bottom, second to last paragraph, the trial court instructed the jury that the verdict had to be unanimous. At the conclusion of the jury instructions, defense counsel again objected to the deliberate sequence on the lesser included offense of assault, page 682. So there was twice he's objecting to the sequencing that the trial court is giving. In any case, it is reversible error because you cannot require a jury to find a not guilty on the greater offense before considering. And again, twice the judge told the jury, if you find the state has failed to prove beyond a reasonable doubt the defendant committed felonious assault, you will then consider the crime of assault. And then he again in bold, and I put this in bold, not the trial court, if, and I repeat this, only if you have found the state failed to prove either of the felonious assault beyond a reasonable doubt, you would then consider whether or not they proved assault. So, what is the jury supposed to think about that? If we do not unanimously agree on felonious assault, we can never get to the M1 assault. The very sentence in the OJI that if you cannot agree, you will then consider was absent in this case. So with that, Your Honor, I'd ask the court to look at the transcripts, look at the jury instructions, and reverse and remand for further proceeding. Thank you.
Thank you, counsel. Thank you both for your presentations. The court will take a matter of advisement, issue a written decision, which will be mailed to both sides as well as posted on the website.